Hello, everyone, and welcome to English Law. So, this is a talk about homicide, particularly murder and loss of control defences. Um, anyway, so I'm going to look at murder and this loss of control defence, um, and murder, the secondary special defence, which is defending oneself on the grounds of diminished responsibility, which is not to say that when you killed someone it was self-defense. No, I mean in the legal sense defense. You're charged with murder and you say, yes, I killed the person, but because of my diminished responsibility, it ought to be reduced to manslaughter. And I shall also examine involuntary manslaughter. So, what's the actus reus of murder? Well, that is killing another person under the Queen's Peace unlawfully. That's as per Coke. Coke was this very famous 17th century jurist. Some dispute whether his name was really pronounced Cook or what. So, when is it lawful to kill another human being? Killing an enemy combatant is acceptable in wartime or some sort of warlike situation. In the advancement of justice, as said in the old days, when we had capital punishment, that was permissible. Killing in self-defense, if someone's trying to kill you or trying to kill another person in order to save the innocent person, you have to kill the baddie. Those are all lawful killings. If you even make a mistake doing this, if you think someone is trying to kill you, then you kill that person. Turns out you're wrong. The other person wasn't trying to kill you, but because you honestly believed it at the time, that's no crime. Anyway, so killing has to be someone who has already been born. Killing a baby in the womb, an embryo fetus, is not considered murder. I know it's contentious. Some people say that it is murder, but at law it is not. Okay, there's R against Poulton, a case about this. Attorney General's reference number 3 of 1994 about this. R against Reeves. And under the Queen's Peace, well, that was defined by R against Adeb Alojo. Okay, so we've got what's the mens rea, as in the mental aspect of the crime, is intending to kill or indeed to cause grievous bodily harm. If you intend to cause grievously bodily harm, you don't actually intend to kill, but nevertheless you actually kill the person, you're still guilty of murder. That was decided in R against Vickers. The defences to murder, as in where you'd be found not guilty if you successfully run this defence, will be self-defence. I had to kill this person because otherwise he or she was going to kill me or going to kill another person. In order to save this other person, I had to kill the assailant. Now, there are these partial defences of loss of control and diminished responsibility, as in you are still going to go to jail, but you're not going to get a life sentence. So, loss of control. There was this defence of provocation previously, but that was done away with in 2010. The Coroners and Justice Act 2009 abolished it, but only took effect in 2010. Now there's a new loss of self-control as per the Coroners and Justice Act, sections 54 to 56. This defence will operate if the defendant was driven to it because of the terrible thing that was done or said by the other person. And we'll look at qualifying triggers in a minute, in which case the defendant shan't be guilty of murder, but shall be guilty of voluntary manslaughter, as per section 54.7 of that Coroners and Justice Act. So the burden of proof here is really upon the defence to prove that there really was such a terrible provocation. This is a qualifying trigger that a reasonable person would have reacted that way, would have just lost it. As per sections 54.5 and 6 of the Act. So there are previous cases which are pertinent here, such as R against Clinton, Parker and Evans. So let's look at these aspects of the defence one by one. First of all, we have to determine whether the defendant slew another person due to losing self-control, as provided for by section 54.1a of the Act, the Coroners and Justice Act. If I say the Act, that's the one I mean for the moment. And was there the qualifying trigger, as per section 54.1b, as in words of behaviour by the victim which was so outrageously offensive that an ordinary person would have just lost self-control and used heavy violence against the victim. It can't be quite offensive, it can't be quite rude. No, it's got to be beyond the beyond. So again, this is a concession to human frailty that you would no longer be able to contain your rage. Anyway, so you have to ask yourself, would another person have behaved in this way? And section 54.1c puts it that way. A reasonable person would have done the same. So you need to look at all three aspects of this and in the correct order. As per R against Clinton, was the killing due to losing self-control? Number one. Number two, was the qualifying trigger? And number three, would a reasonable person have behaved likewise? So the defense needs to prove all elements. If the prosecution can disprove even one element, then the defense is gone and the person will still be guilty of murder. So, looking at whether the defendant lost self-control, the loss of self-control doesn't have to be total, as in R against Richins. So in section 54.2, it says it does not matter that the loss of self-control was not sudden. Okay, that's a direct quotation. It can be a gradual loss of self-control, as in R against Ahluwalia. This is a case of the early 90s. This woman was in an abusive marriage. She was beaten up by her husband over years, and then she decided to poison his food. She put overdose of sleeping pills into his dinner. He died as a result. Anyway, feminists took up her case. They said it was a slow burn thing. Eventually, she'd cracked under the strain. Now, the prosecution said she could have run away. She could have gone to the police, but, he wasn't trying to kill her. But nevertheless, her conviction was reduced to manslaughter. Okay, so it's not a defense if the defendant did what he did out of a desire for vengeance. That won't work. Honor killings or crime passionnel, no. That's as per section 54.4. Look at the qualifying trigger. That's in section 55. So there are two qualifying triggers which are pointed out, and they. Section 55.5 tells us a bit more about them. One of them could be a fear of heavy violence, as per section 55.3. Heavy violence against the defendant who went on to kill the victim, or against another. The defendant did it because my child was going to be severely beaten up, or my sister or my girlfriend or whatever, or my uncle was going to suffer heavy violence. So it's a subjective test. What did the defendant believe, not what an ordinary person believe? And the second qualifying trigger, there are three aspects here. They things that were either said or done, and they must constitute circumstances of an extremely grave character. That's a direct quotation. Section 55.4a provides for that. And lastly, they must have caused the defendant to have a justifiable sense of being seriously wronged. That's for section 55.4b. So if the defendant felt seriously wrong, but it wasn't justifiable, that's no defense. If he called you something very insulting, and indeed you are that very insulting thing, then that you have no defense. Or if he called you something and you justifiably felt wrong, but not seriously wronged, then it wouldn't be that wouldn't be a defense. Remember, it has to be of an extremely grave character. It can't be a few swear words. That's as per section 55.4b. Okay, so there are notes about this. So let's come on to section 55.4 and compare that to R against Clinton. There's an objective test here. So the judge here was named Judge. So Lord Judge in that case, so that's nominative determinism for you. He had the surname Judge, so he became one. He underscored that the fear of heavy violence is a circumstance of an extremely grave character, and there can be has to be a sense of being seriously wronged, not slightly wrong, not fairly badly wronged. So that's deliberately a high bar to meet. We don't want people able to kill each other and get away with manslaughter when they kill someone on purpose. So both of these elements must be present. There must be this something of an extremely grave character and the sense of being seriously wronged. If only one is present, then the defense shan't operate. So what academics think about this? Well, Herring is a legal scholar, and he said that it must be more than the usual discourtesy and offence people encounter from day to day. Yeah, it mustn't be just being let down or say, ha ha, you lost your job, ha ha, you failed your exam. It's got to be much worse than that. Barker and Zhao said, we've got to bear in mind society's mores these days. Things that were regarded very insulting in the past are not seen as very insulting now. For example, saying someone's gay, for instance. So anyway, there are certain things which cannot count as a qualifying trigger. If it's a fear of violence that the defendant has done something to incite. So I'm the defendant. I've been very, very rude to the victim. Victim is then going to come and attack me, and though I kill the victim, well, I provoked it. I started that chain of causation. Therefore, that's no defence. Okay, so or if you do something else, if you're an intruder in their house, and then they insult you and you kill them, no, that's no defence. So okay, it can't be something which D has started off. Okay, that's as provided for by section 55.6b. There's also a case a bit about this, which is R against Dawes, Hatter and Bowyer. More issues which cannot be part of a defence. If you're furious about sexual infidelity, your girlfriend is being bonked by somebody else or whatever, or your husband is having an affair with somebody else, no. If you're a very traditional family and you say your daughter has to have an arranged marriage, she runs off to live with her boyfriend, honour killing, no, that is no defence. So Clinton is a case about that. Anyway, so infidelity to any relationship, no, that's no qualifying trigger. If there was infidelity, but that's not the reason the person was killed, there's something else, there's some other insult to behaviour, then you might still have a defence. If infidelity is part of the whole circumstances, that doesn't necessarily vitiate the defence, but infidelity cannot be the sole reason or the primary reason for the slaying. Okay, let's look at the reaction of another person. We're asking, how would a reasonable person behave in these circumstances, as the defendant did? So section 54.1c says, if a person of the defendant's gender, age, physique, with a usual level of tolerance and self-control in the same situation might have reacted in a similar way, then you have a defence. Notice it's might have reacted, not would have reacted. We have to be certain that an ordinary person would. Because if you're a man and you're quite capable of fighting, then you might be more violent than a woman is usually. Or if you're a young man, higher testosterone, may be more violent than an elderly man. And the trouble is, some people lose their temper when they can afford to lose their temper. A very strong man losing his temper with a very feeble man because he knows he can beat the weak guy up. So that's less convincing. If you're short, scrawny, and have no muscle, and then you lose it with someone much stronger than you and physically attack them, it suggests that person really is losing his temper because you think a weak guy wouldn't start a fight with someone who's very brawny. All right. So more about this question of what would a reasonable person have done in a similar situation. Section 54.3 says the circumstances of the defendant. Okay, if you're in that situation, having regard to all the circumstances that are pertinent to the defendant's behaviour and have a bearing on the defendant's ability to control himself. He might have had some sort of very traumatic or very experience, and if you're taunting about something terrible that happened in the past, then that's going to possibly upset him more. You know, if you're taunting him about how his mother died in horrific circumstances, then that might cause him to lose it. Yeah, so the ordinary person isn't in that situation because most people haven't had their mother die in childhood. But put yourself in his shoes. Might you have lost it if someone insulted you grievously about something which was so agonising? Maybe, in which case a defence would work. So Lord Diplock held forth on this in DPP against Camplin. So what is pertinent to someone's ability to be tolerant and to exercise self-discipline? Well, there's R against Rezhmansky, Gassman. In this case, there was post-traumatic stress disorder and a personality disorder. These are excluded by section 54.3. Seems a bit unfair to me. Is there anything else which might be excluded? Difficult to say. Speculate. So let's look at another category. R against Rezhmansky. Lord Justice Hallett sat on this case, and this is what he had to say. If a mental disorder has a relevance to the defendant's conduct other than bearing on his general capacity for tolerance and self-restraint, it is not excluded by subsection 3, and the jury will be entitled to take into account as one of the defendant's circumstances under section 54.1c, but it would not be relevant to the question of the degree of tolerance and self-restraint which would be exercised by a hypothetical person referred to in section 54.1c. close quotation. So we've got to ask, what would an ordinary person do in this situation? Okay, so R against Wilcox, R against Mohal, and R against Massiantoni are all cases in point. Remember, if we have intoxication, well, that's not going to help you. It's your fault for being drunk. So R against Asmalash said, it's with a normal degree of tolerance and self-restraint. If you're drunk, it's subnormal. So therefore, that's your fault. You're not going to be let off more lightly because you were inebriated. So, okay. So the intoxication itself does not necessarily ruin your defence, but we're not going to let you to get away with a lower level of tolerance because you're drunk. So intoxication is going to be disregarded, right? And we're just going to look at the qualifying trigger, really. Right, that's enough for these loss of self-control offences. Toodaloo.